Welcome to this special edition of Medmarc's webinar series. Today's presentation is titled Force Majeure COVID-19. I'm Kate Klaus, staff attorney in Medmarc's Risk Management Department. On behalf of Medmarc and today's presenter, Jordan Lipp, thank you for joining us. Jordan Lipp is a partner at Childs McCune LLC in Denver, Colorado, where he focuses his practice on product liability defense, outdoor industry defense, and commercial litigation. He wrote the book on product liability law in Colorado, Product Liability Law and Procedure in Colorado, 2nd edition, and he is an adjunct law professor at University of Denver's Sturm College of Law. And with that, I am pleased to turn things over to Jordan.
Hi, everyone, and welcome to this second webinar on the legal issues resulting from the COVID-19 pandemic and the economic fallout from it, and how that impacts the life sciences industry. As I was trying to come up with a title of this presentation, I thought perhaps a more tongue-in-cheek title might be May the force majeure be with you, and perhaps even an image of Yoda on the screen might be appropriate, but considering how dark these days are, perhaps Darth Vader, an image of Darth Vader with the title May the force majeure be with you would be better. Look, force majeure clauses today are in the front and center of everyone's mind, and it's amazing. You know, even just a few months ago, and I'm sure there are folks on the call who've sent me their contracts to review from a legal risk management perspective, and you know, when you hear from me, the first clause that I always go to, that I always look at, is the indemnification clause. We spend a lot of time on that. We talk a lot about the insurance clauses. Those are sort of the typical contractual clauses that obsess people who think about legal risk management. And the force majeure clause is discussed, but it's always sort of a lower priority. And with recent events today, frankly, the hottest clause in a contract from a legal risk management perspective is the force majeure clause. And yes, I know how law geeky that sounds to be talking about what is the hottest clause in a contract. But just to start off, force majeure, I assume most people on the call are generally familiar with it, but it literally means superior force. And outside of legal circles, it's usually considered to be synonymous with the term act of God. It's the act of God clause. And in fact, even in legal circles, if you were to go onto Lexis, let's say, and search the term force majeure, it will automatically and simultaneously search the term act of God. But I don't like using the term act of God when we're talking about force majeure clauses, and I don't like it for this reason, right? An act of God, or also known as an act of nature, it's a natural event. It's a natural disaster, like a flood, an earthquake, a tornado, something of that nature. And force majeure events can be much broader than an act of God. They can include, for example, a war, a strike, a riot, other things of that nature. So throughout the rest of this presentation, I'm going to be referring to these as force majeure clauses as opposed to act of God clauses. But before we really dive into it, we're going to talk for a little while about what happens when there is no force majeure clause in the contract. And so with that, I thought I'd start with just two examples, two cases where it's not present, and we can look at how the courts deal with it. So flu pandemic, it's causing schools in Illinois to be shuttered for a while. And because the schools are shuttered, the school stops paying its teachers for the rest of the school year. So a teacher sues in Illinois state court and sues for her salary while the school is shut down. The court orders the school to pay the teacher's salary, and the court's reasoning behind that was that the teacher had a contract to teach for the full school year. It wasn't the teacher's fault that the flu pandemic closed the school, and the school had to honor that year-long contract, regardless of whether or not she was teaching. So that's one case. If we switch slightly over to North Dakota, right, same situation. School shut down because of the flu pandemic. The school district stops paying their school bus contractor. The school district contracts out their school bus system. School bus company sues the school district for payment for the rest of the school year, and the court orders that the school district does not have to pay the bus contractor. So a different result in Illinois. What was the court's reasoning? Well, the court looked at the contract and said, look, the school district, under the contract, could cancel the contract at any time. So because schools were shut down due to the pandemic, we are going to say that it was a cancelable contract. School district was within its rights not to pay the bus driving contractor. Now, anyone listening to my description of these two cases during this webinar who is familiar with the U.S. legal system knows that I'm not talking about COVID-19 flu pandemic right now. Our judicial system doesn't move that fast. We're not getting decisions, and we won't get decisions for a long time on these issues, these litigation issues related to COVID-19. Rather, I'm talking about the Spanish flu. There is a wealth of cases that arose from the last time there was a pandemic of this magnitude in the United States, and let's hope that this one is much smaller than the Spanish flu. But we have lots of precedent for all the issues that we're going to be talking about today with force majeure and impossibility. Right? If you think about it, the parallels between the Spanish flu and today, the parallels between all the other issues in old cases and today, they're there. Our legal system is built upon precedents of what occurred, whether it's 5 years ago or 100 years ago or 300 years ago. And this is of particular interest when we're talking about force majeure, the cancellation of contracts, impossibility of performance, because as our legal system developed initially in England many hundreds of years ago, pandemics, epidemics, the natural disasters were much more common than they are today. Certainly they all happen today, but not at the same frequency and without the same effect. We've seen over the last several hundred years a massive decrease in fatality rates from epidemics, from natural disasters. So our legal system, I think, is fairly well built to handle the issues that are coming up from COVID-19 today. So with that, let me make sure that we have a quick review of how contract law works. Let's start with some basic contract law. Rule number one, contracts are binding. General rule, you cannot get out of a contract. If you agree to sell a medical device to a hospital or a distributor for X price on Y date, you have to sell that product on Y date for X price. That's what you promised in the contract. Courts don't care if the economy crashes. Courts don't care if there's a new technology that's come out before Y date to make that device more or less obsolete today. Parties are bound to their contractual agreements. A contract is a series of promises between both sides that they will perform. It's a harsh rule, right? The parties are bound to what they agree to. It's a harsh rule, but we as a society want contracts to be enforced. Now, there are two primary exceptions to this, right? There are two primary exceptions to the general rule that we want contracts to be enforced. The first exception is that courts will provide some leniency when there are, to quote the restatement here, extraordinary circumstances. It's almost as if courts will write in certain provisions into a contract forgiving a lack of performance if there are extraordinary circumstances. So that's one exception to the harsh rule that a contract must be performed as it's written. The other exception is what is actually written into the contract, right? Parties can put different requirements into the contract than what the law normally says is sort of the default. There's an obvious example that almost everyone is familiar with, which is a best efforts clause. That the contract, instead of saying, we will sell to you the following medical device at X price on Y date, the contract could instead say that we will use our best efforts to sell you this medical device, right? That's a best efforts clause. It doesn't have that same sort of binding, strict nature. But the other classic example of this is the one that we're talking about today. and that's the force majeure clause. That's where the parties get together before any unforeseeable event happens, and they try to define, well, what happens if an unforeseeable event happens that interferes with the contract. So what we're going to be talking about over the next 50 minutes of this webinar are both what happens when there is the force majeure clause and when there is not the force majeure clause. Now, I'm actually going to start with the basic law, the common law, without a force majeure clause, and hopefully by the end of this presentation you'll agree with me that that's the way to start this analysis, and that's the way to start thinking about force majeure, is we start with saying, well, what do courts say if there is no force majeure clause? How do we analyze that? And then once we have an understanding of that from the first part of this call, then we can add on the second layer, which is, well, let's put on top of that the actual force majeure clause and its language. And we're going to have fun, if fun is the right word, actually looking at force majeure clauses and breaking them down into their component parts so we can understand what they say and how they work. But before that, let's start out with a common law, and I use common law loosely here for those on the call who are not really up on the Uniform Commercial Code versus common law. Common law is what the courts create, and so about half the contracts out there fall under the common law, what the courts have created the law to be. The other half fall under the Uniform Commercial Code. And basically, the Uniform Commercial Code governs the sale of goods within the United States. Virtually every state has adopted some version of the Uniform Commercial Code. And when we say a sale of a good, most of the things that your companies deal with are goods. Drugs are goods. Medical devices are goods. The components that go into them are goods. Anything that's a product is a good, so it's regulated by the Uniform Commercial Code. However, your companies are going to have contracts, even if you are a medical device manufacturer, you're going to have contracts for services. An example I'll come back to a few times during this talk is with your IT provider, right? Your IT provider for your company is providing a service. They're not providing a good. So that's going to be governed under the common law. But fortunately, the common law and the Uniform Commercial Code are pretty similar. For the lawyers who are on this call, as we're talking through these topics, I'll be giving you on the slides citations so you can look for yourself to each of these topics that I'm talking about. For the non-lawyers on the call, don't worry about the citations. It's only for the benefit of the lawyers. This is fairly, I don't want to say simple, these are fairly common sense concepts. You're not going to need to be a lawyer to understand them, and just ignore the citations for the non-lawyers. So with that said, look, I'm an attorney. I always have to have caveats. You heard some pretty big caveats on my Tuesday talk on the PrEP Act. I'm going to do that again, though it's going to be a very different caveat than the ones I was giving on the PrEP Act. Look, we live in a country with 50 different states and the District of Columbia, so we have, for all intents and purposes, 51 different sets of laws. And I'm going to give a general description based upon general legal principles. Each state's law is different. Whatever law your contract is under, you're going to have to look to that law. The second caveat, and this is probably an even bigger one, is look, I know that your supply chains, a lot of them originate outside the United States. I know a lot of your sales go outside of the United States. Today we are talking about American law, U.S. law. I can't possibly in an hour start to cover Japanese law or South African law on force majeure. I do have a resource, and there are a lot of resources out there, but I do have a resource on the screen. The International Chamber of Commerce has put forth a sample force majeure international clause, and we're actually going to look at it later on in today's presentation. And they have with that some notes, and if you are looking for just a quick primer on international force majeure law, that's a good place at least to start. So with that said, I think that we're ready to jump into the first topic, which is impossibility. Now, there's a basic legal principle that one should not be held to a contract that's impossible to perform. So let me give you a simple and frankly rather unpleasant example. Let's say your company hires a specific regulatory expert to guide it through the PMA process. You're going to rely on this specific consultant, and then before they start to consult with you, that consultant passes away. Obviously, at this point, the consulting contract is impossible to perform. The consultant who you hired is now deceased. That is a classic example of an impossible contract, and the contract, as a legal matter, gets canceled. And attorneys like to use the term impossibility or impossible, and that's a term that I've been using. But the better term and the more legally accurate term for this concept is impracticality. And you'll oftentimes hear this referred to as just impossibility as opposed to impracticality. And I think part of that is just, frankly, it's hard to say impracticality and it's hard to spell impracticality. And I'm a little paranoid that I'm going to mispronounce it throughout this throughout this talk, or that I'm going to misspell it on one of my slides. And it doesn't have the same ring to it as impossibility, but really we're always talking about impracticality. Because it's not impossibility, but impracticality is what renders a contract unenforceable or void. So, what makes a contract impractical? Let me start with what does not make a contract impractical: the financial conditions of the parties. Over the last 2 weeks, I've been fielding a lot of phone calls from a lot of my clients in a lot of different industries. And I'm hearing a lot of them saying, Jordan, we have to get out of this contract. We have to get out of this contract now because we're losing money like mad and we can't perform under this contract. We can't afford this contract. This is what I've been hearing for the last 2 weeks. And I get that that might be the real reason why a company might want to cancel a contract. And it may be a good argument to tug at the heartstrings of the party on the other side of the contract, because in many of these cases, these are contracts that have been going on for years with a supplier or a vendor. But that's not a legal reason to get out of a contract. You cannot legally get out of a contract because you're losing money like mad. The financial condition of a party is not something that gets one out of a contract shy of bankruptcy. What else does not make a contract impractical? A change in circumstances that makes a transaction less profitable. If things have changed and there's less profit from the contract, that's not good enough for impracticality. Another example of what does not constitute impracticality is if there's an alternate way to perform the contract. So let's say your supplier, your main supplier was giving you the raw materials from China. That has been shut down due to COVID-19. Well, can you get the supplies in a reasonable quantity at a reasonable price from South Africa? If you can, you're not in an impracticality of performance of the contract situation. So those are things that are not impracticality. A lot of people think they are, but they're not legally. What is impractical? Well, let me give you a few examples. First, a severe shortage of raw materials caused by a pandemic that makes the sale of the goods based upon those materials impractical. The destruction or the long-term quarantine of the products that go into your that are either the components or are the final products, that can make a contract impractical. Or severe personal danger in performing the contract. The classic example, perhaps not as applicable today to COVID-19, though it will be interesting to see how courts tease out the issue of people putting themselves in danger of the coronavirus in order to perform a contract. But the classic example is, let's say there's a contract to deliver a product to a certain country by ship. And then a civil war breaks out in that country, and the rebellion says they're going to sink any ship that goes into any port in that country. The courts are not going to hold a party to their contract to deliver a product if that means that they face a real likelihood of getting killed as they approach the port. So those are all things that make a contract impractical. And in fact, that's probably a good example of the difference between impossible and impractical. It's not impossible to deliver supplies at a port in a war-torn country. You can do it. Your ship might just get sunk. But it's impractical to do it because the courts are not going to hold a party to contractual obligation where they face a real likelihood that if they perform under this contract, the ship that they're performing this contract under is going to get sunk by the rebels. Hope that makes sense. But the biggest impracticality out there, and the one that I think is going to be most important during this pandemic, is what I'm going to turn to next. And that is that a contract is impractical, and thus we don't have to follow a contract if it violates a government order. And once again, this is a great example of the difference between impossibility and practicability. A court will never say to someone that you could have performed this contract, you just might have had to go to jail by performing it. It doesn't work that way. So, let's start with a basic legal principle. Courts tend to frown on contracts that are illegal. There was a great headline in the Aspen Times, and this is the type of thing that only happens in Aspen, Colorado, a few years ago, where a woman called the police to report that a buyer had stolen her cocaine. So you cannot go to a court with a contract for the sale of cocaine and sue the other side for breaching that contract. Courts do not enforce illegal contracts. And so that's going to come up a lot in these force majeure cases and these impossibility, improbability, impracticability cases under the COVID-19 pandemic, because there are all these stay-at-home orders, all these do not congregate orders, and they all came out after the contract, right? If a contract's written today, when we know what's happening, it's different. But when you write a contract 6 months ago or 2 years ago, no idea that there's going to be a nearly nationwide stay-at-home order in place, that can mean that the contract may not get enforced because today it's illegal. So some important points for you to think about as we talk through what is a contract in violation of government order. It doesn't matter where the order comes from. It can come from the local health department. It can come from the President of the United States. It can be state, local, federal, doesn't matter. Same thing is that it doesn't matter whether it's a law or a regulation or an order. Courts are not going to enforce a contract that requires the violation of the law. Interestingly, it also doesn't matter whether the law or regulation or order is legal or not. We can all imagine 6 months from now, some court declares that some of these stay-at-home orders are unconstitutional, that they violate the 14th Amendment by taking away liberty without due process, or they violate the First Amendment as it bans assembly for public protest or bans attendance at a house of worship. Will that happen? Will it not happen? I'm not a constitutional attorney. I can't tell you that. But there's that possibility. But what matters for contract law is that courts don't want one party to say, oh, well, this order, this government regulation might be ruled someday to be unconstitutional, so a party had to violate the order. No, courts are not going to do that. Courts are going to say that if there's an order from, whether it's the public health department or the president, a party should follow that, regardless of whether it's accurate or not. And then even if the order someday gets overturned, gets ruled unconstitutional, we don't care. The party did not have to perform under the contract in that circumstance. So I think at this point, though, there's a big caveat of what is a violation of a government order and what is not a violation of the government order. So let's say your medical device company had arranged for a team building retreat next week, and you have a contract with the facility for this team building retreat. It's a good chance it would be illegal, depending on what state you're in, but in most states today, it would be illegal for your company to have that team building retreat because it would violate the stay-at-home orders and the social distancing rules, and because of that, the contract for the team building retreat gets canceled as a matter of law. It's not whether it's in the contract or not, just the contract is now an illegal one. But compare that to your contract with your IT company. Your IT company might be under the same stay-at-home order as anyone else, but of course IT can happen from home. The IT company can still support you from other people working at home. It may be more expensive for the IT company. They may make less of a profit if they do it, but they can still do it. So performance by your IT vendor, that doesn't violate the government order. So I hope that distinction makes sense. I want to talk next about frustration of purpose, but before I do, I realized I forgot sort of a critical point that the courts very much care about under all these circumstances. If there is an event like the COVID-19 pandemic that means that it's impractical for a party to follow the contract, that party must provide notice. The company still has to provide notice that there has been this event and they don't think they're going to be able to perform on their contract. And the company still has to perform as much as they can. So let's say your component part supplier has 50% of the materials they promised to deliver to you next week. Even if they declare a force majeure or an impossible event, they send you the proper notification that they still have to send you the 50% of materials that they currently have, as long as they can send that to you without violating a court order or there's some other impossibility or impracticality of it. Hopefully that makes sense. Let's dive into frustration of purpose. So there may be contracts today that are impossible, or I shouldn't say that are possible to perform. They're certainly not impossible to perform, and in fact, they could be performed just fine. But the whole purpose behind the contract is gone. So let me give you an example that I thought of in light of recent events. Let's say for the 2020 Summer Olympics, a company had bought a large amount of advertising space on the billboards for summer of 2020 for the Olympics, right? Goal is that those billboards are going to be seen on all the news coverage. They're going to be seen by the millions of fans flocking into town for the 2020 Olympics. Now, as we all know, the 2020 Olympics have been postponed. Now, this contract to put up billboards, it's still possible. It can still happen. It's easy enough in today's climate to put up billboards and take them down. But the entire purpose of the contract, the entire point of the contract, which is to get these billboards up for a specific event, that's gone today. So that's what is under the doctrine of frustration of purpose. So hopefully everyone's with me here. Frustration of purpose is a different concept than impossibility or impracticality. But it is still a legal doctrine where courts will allow that billboard company, presumably, to pull out of that contract because the whole point of the contract is gone. So let me give you an example closer to home. Let's say your company distributes equipment for elective surgeries. Now, as we all know, most elective surgeries in this country have been put on hold, on hiatus, for a long time. Now, there's nothing impossible for you to sell this equipment for elective surgery to the hospitals and doctors, and there's nothing impossible for those doctors and hospitals to buy it. It's just a sale of goods. but there's a question, is the whole purpose behind the contract has been frustrated because there is no elective surgery. Frankly, there's a lot of precedents for courts to go either way. There's a lot of precedents for courts to hold both sides of the contract and require the sale of that equipment for elective surgery, and there's a lot of precedents going the other way, saying that the parties won't be held to the contract to have to buy and or sell that equipment. So now that I've sort of laid the groundwork for force majeure, now that hopefully everyone understands how the common law and how the Uniform Commercial Code looks at this with the absence of a force majeure clause in the contract, I want to actually dive into force majeure clauses. So we talked earlier about the International Chamber of Commerce's model force majeure clause. To get it onto the slide, I had to go down to 6-point font, and a lot of contracts have this sort of robust force majeure language, much like the ICC model language. But we only have an hour here, and I want to really unpack these clauses, work through them, and so everyone understands them. So we're not going to talk about the long clauses. They'll be aware they're there, and you should be reading them if you have them with your company, or you're a litigator and dealing with or an advisor to the company, and that's what the company has. We rather are going to look at the short versions of these short force majeure clauses. So I put up on the screen the classic example of a force majeure clause. It comes straight from the main treatise, Corbett on Contracts. It's up there. We will deconstruct this in a minute. We'll unpackage it in just a minute. But let me first try to give you the tools of how to read a force majeure clause. This is the anatomy, so to speak, of a force majeure clause. First of all, first question to think about, is this clause mutual or is it one way? What does that mean? Does this mean that either party can back out of a contract if there's a force majeure event, an event that causes this clause to come into existence? Or can only one party back out? Is it only the seller that can say, oh, there's been a force majeure event, I no longer have to sell? Or is it both the buyer and seller? So that's part one of the anatomy of force majeure clause. The next piece to think about is, what are the covered force majeure events? Right? And this is always coming up in commercial litigation of, was a strike, was a flood, what event was sufficient to trigger this force majeure clause? And so here, obviously, we're talking about either was the coronavirus itself sufficient as a covered event, or was the economic catastrophe as a result of the coronavirus, or were the government orders as a result of the coronavirus enough to trigger these clauses? Okay. The third piece of anatomy for a force majeure clause is the effect of the clause, right? Because the clause can be written in a lot of different ways. Let me give you some of the common examples, right? If there's a force majeure event, does that mean that the contract is just canceled? It means like the contract never happened. Or if there's a force majeure event, does that simply suspend the performance of the contract for the period of time that the force majeure event is going on? To go back to the example of selling medical equipment for elective surgery, does it mean that the contract's canceled and you have to start over again once this pandemic is over? Or does it mean that the contract's still in force but everything gets pushed out by the 6 months or however long this event lasts for? So there's the effect. Another common term is that there will be no damages as a result of a force majeure event. Even if a party breaches the other side, breaches the contract, fails to perform under the contract, the other side can't sue them for damages. And then finally, the fourth piece of it, whenever you're reading a force majeure clause, the fourth piece to look for is, what are the notice requirements? What does a party have to say to the other party of the contract about whether a force majeure event is happening or not? So with these four pieces, with these four anatomical pieces of a force majeure clause, let's go back to the Corbett on Contracts example clause and let's unpackage it. First two words, neither party. So we know right from the first two words of this force majeure clause that it is a mutual clause. It applies to either party in the contract. It doesn't just apply to the seller, it applies to the buyer just as well. Okay. Then, continue on, neither party shall be liable for its failure to perform. So what is the effect of this force majeure clause? The effect is not to postpone performance until the event's over. The effect is not to cancel the contract. Rather, the effect of this force majeure clause is to say that neither party is responsible to pay damages, that either party can breach the contract, can fail to perform, and even if they do that, the other side can't sue them for its failure to perform. Okay. So then let's look at what is the force majeure event. And this language says it's something that's made impracticable. And right, we're bringing back this common law concept that we were talking about earlier in the presentation of contract being impossible or impractical to perform. And then it goes into, due to any occurrence beyond its reasonable control, including acts of God, governmental law, ordinances, rules, and regulations. Okay. It does not say epidemics. It does not say pandemics. In a minute, we're going to look at a clause that does actually call out pandemics. But for now, looking at this sample clause, we don't have that. Now, barring unusual circumstances, I would be surprised if a court says that this pandemic is not an act of God. An act of God is, and this is just from the dictionary, quote, an overwhelming, unpreventable event caused exclusively by forces of nature, such as an earthquake, flood, or tornado. Right, so if that's the definition of an act of God, I would certainly think that COVID-19 would fall within that definition. Look, of course there's an argument that COVID-19 wasn't exclusively caused by nature because its spread could have been slowed or the spread could have been stopped by better actions by governments, companies, individuals. But of course the same thing could be applied to earthquakes, or tornadoes or floods, right? You can build more dams, you can build buildings with better systems in place to survive stronger earthquakes. So most likely it will be an act of God. Of course, now the question is the failure to perform really because of this act of God, so to speak, right? Let me go back to the IT firm example, right? Your IT firm could still perform in spite of the fact that there has been this act of God, this pandemic. So hopefully that makes sense. This clause, I think, would also probably apply to a lot of COVID-19 related issues because it talks about governmental laws, ordinances, rules, and regulations, right? And that's a lot of what's preventing companies from performing right now. Okay, so let's take a look at another sample clause. Don't worry, I only have one more after this one, so we're not going to spend too much time in this presentation looking at these clauses, but it's important to spend a little time at least. So this clause says at the very beginning, MFI, the seller, may suspend performance. Okay, right there we see this is not a mutual clause, this is a one-way clause. Only the seller can invoke this force majeure provision. And how do they invoke it? Well, they can suspend performance. So we're not talking about canceling performance, and let's actually go down to the bottom line that I've highlighted here. What is the effect of this clause? That the time for performance of the affected obligation of MFI, the seller, shall be extended. In other words, the effect of this force majeure clause is to make sure that we've extended out the period of time so performance happens once the force majeure event is over. So I also pulled out this clause so folks can see it is fairly typical for force majeure clauses to include terms such as epidemics or quarantines, and this clause does indeed have that. So there's almost no question that this clause that would apply to the coronavirus because it is was an epidemic, now is a pandemic. So the one thing that you'll note, we've looked at three different clauses, but really we've only looked at two, this one and and the corporate on contracts example. But neither of these clauses mention notice. So I wanted to show everyone what a sample notice clause looks like. And so here on the screen, this is one where you must give prompt telephone notice, and then you must confirm in writing that there has been a force majeure event and provide the estimated duration of this force majeure event to the other side of the contract. And the reason why I pulled this one is that it is actually a really interesting case, and I think maybe informative of how courts are going to view the force majeure claims under the coronavirus, especially because this case actually involves a disease, albeit a very different disease. Now, make no mistake, this is a decision from the Northern District of Iowa. It's federal court. It's going to be persuasive, not much in other jurisdictions, only to some extent even in the Northern District of Iowa. But it raises some very interesting pieces for our current situation. This case involves a hog buying contract. And when porcine reproductive and respiratory syndrome, PRRS, decimated hog populations in this part of Iowa, a group of hog sellers who couldn't perform their contract tried to use, when they got sued for not providing hogs, tried to use this clause, this force majeure clause, as a defense to the lawsuit. Now, when the buyer, who was not sold the hogs, sued the sellers, everyone agreed that PRRS was a force majeure event, right? The hog herds, I assume herd is right, but whatever it is, the hog population had been decimated by PRRS. We have a force majeure event. However, of the sellers, only one of them provided notice, and the one who provided notice maybe did it right, maybe didn't do it right. So the court said that the one seller who may have provided notice, will let the jury decide whether that seller provided adequate notice. But for all other sellers, they did not provide notice. That's not disputed. So none of those other sellers can use the force majeure clause to protect themselves. So here was just a classic example of a simple mistake by the sellers of not invoking the force majeure clause, not providing the requisite notice to the buyer of this force majeure event, even though everyone knew what was going on, and that was enough in this court's mind to eliminate the defense of force majeure. Okay, I know that this has been a lot of information very quickly. So before we move into questions, I wanted to just recap. What are the takeaways on force majeure clauses? What should you be doing tomorrow as to all your contracts in this troubled time? First, check your major contracts and the contracts you're worried about. Do they have a force majeure clause? If they don't have a force majeure clause, then you'll have to think, if you're the one trying to get out of the contract, or if you're concerned that the other side is trying to get out of the contract, do the common law or UCC rules regarding impracticability, regarding frustration of purpose, regarding impossibility, do they apply? If there is a force majeure clause, break it out the way that we've been breaking it out, or at least that's my advice, of course, or my thoughts. Look first, is it mutual one way? Is the current pandemic a covered event? And when you do that, don't just look for the word pandemic, or don't just look for the word act of God. Also think about, the covered event is usually something that makes performance of the contract impractical. So is this a contract that can still be performed, or is it impractical? Next is, what is the effect, right? Can your supplier just stop supplying to you and you're stuck with that, or does it just mean that your supplier has to continue to perform the contract, they just get to delay a few months before they perform it? And then finally, what are the notice requirements, and are those being met? So, as to notice, if you're the one who has to stop performing due to the pandemic, have you done your notice? And have you done it properly? And remember what we talked about earlier. Under the UCC and under the common law, you still have to provide notice. So even if you don't have a force majeure provision, you should still be providing notice. And as we talked about earlier, your notice shouldn't start off with, these are horrible economic times and we're losing money like mad and we don't have money to perform. That's not a good reason. Make sure that you're actually talking about why you can't actually perform, why it's not possible or not practical. Now, on the other hand, if it's the other side of the contract, if your supplier, if your vendor, if they're not performing, take a look. Have they done the notice? If they haven't done the notice, that might be very helpful down the road for you. The other thing, and I was just alluding to this a moment ago, to think about is what is the reason? What is the reason why there's not performance? Is it financial difficulties, in which case contract still has to be performed unless someone declares bankruptcy? Or is performance not occurring because all of a sudden it is impossible to ship the goods across the ocean to us right now in light of the pandemic? And the other question that you have to be asking yourself, either side of the contract that you're on, is can the contract still be performed, but be performed in an alternative way, right? Is there some other way that we can get this service, that we can get this product to people not the traditional way? Because the contract is still enforceable if there is a reasonable alternative manner. So, to sum up, regardless of which side you're on right now, and your company or your client may be very well on both sides of this issue, depending upon what the contracts are. I hope the force majeure is with you, so to speak. I hope the clauses and the laws favor your interest during this difficult time. So thank you, everyone, and I look forward to the questions.
Thanks so much, Jordan. We do have a few questions for you. First, could you discuss some of the legal strategies around the enforcement of force majeure and how a company might defend against it?
Sure. Okay. So legal strategies. So this is so I'm involved or going to be shortly involved in in litigation involving the enforcement of a force majeure clause. If I want that clause to be enforced, first things first, make sure that notice is provided and it's provided correctly. Second, make sure the notice and pleadings explain why the pandemic or the government's response to the pandemic specifically is causing me not to be able to perform. Right, the stay-at-home orders, the travel restrictions, whatever it is, why that is stopping the performance. And then, right, I don't want to get into legal weeds, right? This comes up in litigation in two different ways, right? First, either a company can file a declaratory relief action where they go to the court and they say we should not have to perform this contract, and then the party that's not performing, they're the plaintiff. Or it can be raised as a defense if they get sued for not performing. So let me stick with a deck action for just a second. If I'm doing a deck action as an attorney, I would want to raise every argument that I could in that deck action. So I would assert that I don't have to perform on this contract because, 1, the force majeure clause, 2, impossibility, 3, impracticality, 4, violation of government order, possibly 5, frustration of purpose. The reason why I would raise every single one of those is the judge would have to say no to me on 5 different times for 5 different reasons. It's a lot more that's likely to be successful than just simply relying just on one of them, just on the force majeure clause. So those are some sort of off-the-cuff strategies to enforce. Now let's switch to the other side, right? We're in litigation. We are trying to say that a force majeure clause should not be enforced, right? Well, first of all, let's hope the other side messed up and didn't provide notice. That's a great get-out-of-jail-free card. Will it work in every case? No, but it will work in a lot of cases. So look to notice. Next, and perhaps even bigger, what were the breaching party's alternatives in terms of performance, right? Courts want to enforce contracts as they're written. And there's a general sense that a contract should be enforced as it's written. So was there an alternative way for that company to still supply the goods or supply the services? If so, then presumably the force majeure event or the impossible event didn't really occur. And then another one is, once again, try to put this into the area that the breaching party is doing this for financial reasons, not because it's impractical to perform or it's against the government order to perform, but they're simply doing this because they're losing money, right? And we talked about this a few times already in the presentation. Losing money alone is usually not a sufficient defense. So those are some of the just initial ways to think of this if you're going to be litigating them. And of course, we'll have a much better body of case law 1 to 4 years from now on what's working and what's not working in the litigation over force majeure clauses.
Okay. Another question, can a party, or does a party get to use both a force majeure clause and the common law?
Well, it's funny because, right, I just said on the deck relief action, right, I would, if I was the attorney for a party who filed a deck relief action, and in my declaratory relief action I was saying, look, court, don't make me perform under the contract, I get out under force majeure, I would try to argue both force majeure and the common law. And presumably the party on the other side would argue no, that the contractual terms have supplanted, have replaced the common law and the Uniform Commercial Code. The reality is both sides have good arguments on that, and courts have gone both ways on that issue. Some of the and courts falling down on different sides of the issue. Some of that depends upon the circumstances of the case. Some of that depends upon the contractual language, right? Is the language exclusive or not? You know, if it says the sole and only remedy for a force majeure event is this, then you're much more likely to not get the common law or UCC benefits. Right, rather the contract's written more narrowly. On the other hand, is some of the contract clauses that we looked at, they talked about things like the contract no longer being practical to perform. Well, that's a common law term. So whether or not the common law technically applies, the court's going to look to the common law to try to interpret the clause. So I can't really give a yes or no answer to the question. I hate to give that lawyer answer of, well, it depends, but it depends.
I think the last question we have here is sort of, along the same lines. If a company has an exclusive supply agreement with their vendor and the vendor can't perform or can only perform in a limited capacity, and you have the Corbin contract style force majeure clause where you're really just saying that there would be no damages in the event of breach, can that company go find themselves an alternate vendor, or are they still going to be bound by the exclusivity?
Great question. I wish I had addressed that earlier. Okay, so the UCC has a provision on this, and the restatement second of contracts has a provision on this, and they were probably even in the slide deck. You just have to dig in, and I just don't. I mean, UCC is 2-615. Obviously, it has to be state by state and what law the contract is under, but part of the concept here is that when one party invokes the force majeure clause and stops supplying, the other party gets let out of a lot of its contractual obligations. Right, so under the example that you gave, and right, once again with the caveat that I'm not actually providing legal advice here, and right, so many other factors, but in most states, the courts would say, yes, if if your vendor, who is your exclusive vendor, cannot provide under force majeure provision what they promised to provide, you, the non-breaching party, are allowed to cover your loss, so to speak, to go out and buy this otherwise. So that is a protection that the non-breaching party, the party that's still able to perform, gets is they get out of their contract, so to speak, to the extent that it applies to this. Obviously, with the same caveats that it really depends upon jurisdiction and location, but as a general matter, they do get out.
Okay. And I think we have time for one more question. This is from one of our listeners. If the services cost more to fulfill, is that party responsible to incur the cost of the overrun, or if they're under strained conditions because of the governmental stay-at-home order, would they have the opportunity to renegotiate the terms and attribute the cost between both parties?
So let me answer this in a bit of a circular route. So one thing that a lot of companies today are doing, and I apologize if there are any landlords on the call, but one thing that a lot of companies are doing today throughout every industry is they're calling up their landlord and they're saying, we're in trouble, you need to cut us a break and we want rent abatement. And to a large degree, there are a lot of landlords who are doing that. That's a renegotiation. It's not a legal system, so to speak, right? The lease is written contractually. You have to pay your rent no matter what, unless, there's some certain event. But usually you're bound to pay your rent. You have to pay it. But all of a sudden there's negotiations going on because the landlord would rather have someone paying reduced rent than have the company have to file for bankruptcy. So the piece of the question that goes to renegotiations can always happen. Right, and we know this oftentimes. This is when you get your outside counsel off the phone and you get your CEOs calling each other directly, because oftentimes a lot more can be accomplished with that than with the lawyers on the phone, and then afterwards the lawyers write out how the deal should work. But renegotiation can always happen, but that's not the legal system, right? That's the contract system that we then will put in place a formal contract, sign it, here's the rent abatement, and then it becomes part of the contract and enforceable. The half of the question before the new renegotiation is, are you stuck with the price? And the answer is, what does the contract say? There are some contracts that are written that consider what the input costs are and adjust input costs to the price of the ultimate goods being sold. This is broad over all industries. Those are unusual. You certainly see them, but they're unusual. Rather, the more typical contract is, we are going to sell you Z widget on X date for Y price. And whoever the seller is stuck, even if the price of Z widget has gone through the roof. Or same thing, the buyer is stuck if the price of Z widget has dramatically plunged. Right, this is the whole idea of the contract, is we're making an agreement on the future of what the price is going to be. So under most contracts, you don't get to change it just because the underlying conditions have changed, unless we're getting up to that high threshold of impracticability or a violation of government order or something of that nature. But of course, just because that's the contract law, that doesn't mean you can't try to renegotiate, and that might be the appropriate thing to do under the circumstances. So hopefully that answers that question.
I think so. And I think that is all the time we have for. We're reaching 3 o'clock. Jordan, thank you so much for this excellent information, both today and in Tuesday's presentation on the PREP Act. This information is timely, and I know it will be very valuable to our audience. Thank you for joining us. This concludes today's webinar.